Hi, I'm Steve Carlson, and today I want to lay out for you my positive, constructive positions on how to restore the United States Constitution and Minnesota Constitution and constitutional rights. This is a hot-button issue that is important to you in the 2014 elections, and specifically on August 12th, which is Independence Day in Minnesota, when you can vote to protect your independent political party and your constitutional rights. I am well able and bring experience and a track record to this issue. It is one of the most critical issues of the 2014 congressional elections, in which I ask for your vote on August 12th, Independence Day in Minnesota, in the independence primary. Without trying to be an alarmist, I want to tell you right now that I believe this nation is indeed in a constitutional crisis, and Minnesota is in a constitutional crisis. The actions against Bill Clinton, I believe, were the early signs of this, and the circumstances of Bush v. Gore. Origins of this constitutional crisis lie in the struggle for power between two major parties, Democrats and Republicans, representing ostensibly irreconcilable ideologies and goals, or at least that is the way it's portrayed in the media, and the way it's acted out in the national elections, which are creating ever greater rifts, threatening the stability and very identity of the United States. I view the fissures which we now witness, many of them involving the Supreme Court, rogue federal judges, a presidency that sets itself apart from and in competition with Congress and the Constitution, as similar to the time of Nixon and Watergate. And the Senate itself plays a key role in leading this constitutional crisis. And Al Franken in the Senate and Amy Klobuchar are right out there in leading it. That's why if you elect me on August 12th to face Al Franken, I can directly confront and abate the crisis. I've already made a video at my website about Al and Amy presenting amendments to the First Amendment. And I'm not talking about any kind of Senate bill. I'm talking about the actual First Amendment. It is not unfair to say they want to actually repeal the First Amendment of the United States Constitution and Bill of Rights. But I discussed that in a video already, and I'll say more about it later. This crisis is similar to the constitutional crisis during the time of Richard Nixon, when the Democrats impeached him after getting thoroughly drubbed in 1972, and we had a constitutional crisis, and impeachment was the road followed to address it. Now I view these crises as a symptom of this historic election struggle. They are more birth pangs of the nation. The first being the Revolutionary War and struggle for political rights itself in the 18th century. Then the Civil War of the 19th century, and now a really defining moment in our nation and its Constitution. The four constitutional fissures I see now in 2014, and which need to be directly addressed in the election with Al Franken, are 1. First Amendment attacks and attacks on fundamental rights to run for office and to vote. 2. Violations of religious liberties and rights of the unborn, and protections of marriage practices. Now these first two fissures clearly violate the Minnesota Constitution, as I will explain below, and we can and must seek refuge in that state constitution, where it has not been preempted by the federal Constitution, and I believe it has not been so preempted. 3. Abuse by government agencies, especially the IRS, but with links to the FEC or Federal Elections Commission, and now spreading to health care and education, where these are being used to effect national social change, but threaten our individual liberties and family rights. And 4, violations of not only privacy, but search and seizure, best known with respect to the NSA, where the Independence Party's endorsed candidate comes from. I am asking you to vote for me instead of the endorsed candidate in the Senate primary. I have studied the Constitution and the law, and listened to a wide range of debate on the constitutional dangers, and concluded that because of our strenuous political contests, which too often resemble mobocracy, and the ignorance of the Constitution which underlies them, the actions of the United States Senate are now creating great jeopardy to the constitutional foundations of the nation. And again, some may say that I'm an alarmist, but I'm certain I'm not. And if you vote for me in the Independence Party primary, I'll raise these against Al Franken and the Republican establishment candidate, and I'll take them to the United States Senate to protect our Constitution and the rights it secures for us. Let me briefly discuss each one of these areas of constitutional peril, and I will discuss how these are being manifested in the state of Minnesota, and unfortunately are even at the heart of the problems in the Minnesota Independence Party itself. My differences with the small group I've described as a clique that has seized control of the Independence Party are profound, momentous constitutional differences. As I've said, they are a threat not only to the future existence of the Independence Party, but to the Constitution of the United States and also the Minnesota Constitution. Let's take a quick look at our Minnesota Constitution, and you can see the burden placed on those rights by the actions of the Democratic Party at this time. And the Independence Party clique has just been in lockstep with these Democratic actions. Spurred on by Barack Obama and Keith Ellison, they paint all those who do not approve of their radical change as haters, unfortunately, and are really driving mob rule in the elections, which we need to correct on August 12th. By electing me to face off against Al Franken. And this labeling of opponents as haters is amplified at the level of federal government. Needless to say, the 41% of voters who are independent of the parties cannot approve of these destabilizing actions by Senator Franken and the Democratic Party of Barack Obama. To start with, elections. I'll cite the Minnesota Constitution, Article 7. Elective franchise, which is to say the right to vote under the state constitution. In Section 1, it is promised, quote, every person 18 years of age or more who has been a citizen of the United States for 3 months and who has resided in the precinct for 30 days next preceding an election shall be entitled to vote in that precinct, unquote. That is an entitlement. And so for choosing a U.S. Senator, that entitlement is the basic building block for the direct election of the U.S. Senator. So the state is violating its own state constitution if it denies the right to vote at the precinct caucus to any of these people, with the exception of persons convicted of treason or felony unless restored under guardianship, insane, or not mentally competent. And yet, the state legislature has passed a statute abridging and denying this right to vote to whole classes of voters, including white males, in the DFL precinct caucus, because the state has given the force of law to quotas for voting and participation based on gender and race. I have a separate video about this at my website, Steve Carlson for Congress 2010.com. Now, I talked about Richard Nixon in the 1972 impeachment after he drubbed George McGovern. What you may not know is that George McGovern and Don Fraser headed a committee in that year creating these gender and race quotas, resulting in McGovern even getting nomination for the Democrats to face Richard Nixon. I was overseas at the time and didn't realize the full scope of the ground shifting beneath us. I'm sure you've heard that from Barack Obama. Yes, we do realize it is, and how. But now I do know how it happened, and I want you to be in the know as you vote August 12th. Another key fact. It was Hubert Humphrey and Walter Mondale, both from Minnesota, who initiated this quota system, beginning in 1968, and leading to the McGovern-Fraser Committee that has messed up the American political scene beyond all recognition. And after the 2012 election, and after I filed a lawsuit about affirmative action in party endorsements and platforms, Governor Mark Dayton named 2 new members of the Minnesota Supreme Court, even though the Minnesota Constitution requires that they be elected, Wilhelmina Wright and David Lillyhaug. And Lillyhaug represented DFL Senator Al Franken as his attorney in the mandatory recount and litigation in 2008, which resulted in Franken being named senator by the Minnesota Supreme Court, although Norm Coleman led in the initial count. Then they found more votes in the mandatory recount. To clarify, Wright and Lillehaug came after the 2012 election, while Lillehaug represented Franken in the 2008 election. This basically upset the whole national political order. So this arrangement, which the Star Tribune called proportional representation, restricts white male voters at the precinct caucus to 35 to 40%. And it's being challenged in the federal courts because in addition to violating the Minnesota Constitution's voting rights expressed in the elective franchise provision, it is in clear violation of the voting rights of the U.S. Constitution, 15th Amendment, barring denial or abridgment of the right to vote based on the race of the voter, and the 19th Amendment, barring denial or abridgment of the right to vote based on the gender or sex of the voter. Further, the right to vote in the federal elections is a protected right in the U.S. Constitution, giving Congress the power to regulate that right, and it has regulated that right by proposing in the U.S. House of Representatives the 15th and 19th Amendments, which, as I said, state election officials and the Minnesota State Legislature are violating. They violate that right by giving the force of law to the, quote, principle, unquote, in the DFL Constitution that delegates selected to vote on endorsing Al Franken or Amy Klobuchar or Betty McCollum to be on the general election ballot must conform to the percent of groups in the Minnesota population as a whole. So they divide the electorate of the state into groups, the largest of which, of course, is women, DFL women. Now I realize that in Minnesota the party is also required to hold an open primary, and you can overturn that corrupt endorsement process. This August 12th, Independence Day, primary election for the U.S. Senate is a critical point when you can say, enough already. We're going to follow the U.S. Constitution and its protections against racial and gender discrimination against white males or anybody, and we're going to vote for Steve Carlson in the Independence Party so that we can salvage our constitutional rights, which I'm going to go through. Now, I'm not just talking about reverse discrimination, in which minority groups embrace discriminatory practices that actually don't work, but instead give power to other groups. And this is a great example of that. The DFL voting arrangement puts the power of the vote that black voters would justly exercise and other minorities, and just plain Minnesotans, don't you know, if they weren't groups, into the hands of a mass of fairly off-the-wall white women. That's right, people like Planned Parenthood, for instance, or those who think marriage is defined to include, quote, acts of licentiousness or practices inconsistent with the peace or safety of the state, unquote, as quoting from the freedom of conscience provision in our Bill of Rights. Now this is also known as homosexual and lesbian marriage, quote unquote. And furthermore, this DFL arrangement empowers homosexual and lesbian political activists at the state convention, while it restricts blacks, Hispanics, American Indians, and Asians, because none of those groups, as they're called by Democrats, constitute at least 10% of the state's population. Of course, the DFL doesn't reveal how exactly it manipulates these quotas. It just says, if you don't follow them, your delegation could be challenged and rejected and not seated. And the state says, if you don't agree with these shenanigans that they call principles, you can't vote at the precinct caucus. You can't even participate. You don't need to show up. And the DFL says it doesn't need to follow any U.S. Constitution in its caucuses and conventions because it's a private organization that just happens to name individuals to appear on the general election ballot. And the judges back them up. I first really investigated this when in a debate I had with Betty McCollum, who greatly benefited from gender manipulation in getting her endorsement from the DFL party. She said, I want to fight for voting rights. And I thought, wait a minute, voting rights. Look at how she is denying voting rights based on gender. Now, in case you're not familiar with the DFL Constitution, you should be, because it defines your constitutional right to vote in the DFL precinct caucuses. And if you just vote Democrat, you might not even know that they are socially engineering the state convention, and that by that time it's just for show, not substance, not liberty and freedom. The political parties are required to file constitutions with Mark Ritchie. But his lawyer, Lori Swanson, the Attorney General, told me that is just paperwork. Mark doesn't know what's in them, and he doesn't care. He's just kind of a glorified filing clerk. And by that I don't mean to demean filing clerks. I've done it. It's critical, but a filing clerk doesn't have any discretionary power. So Secretary Ritchie is saying that he doesn't have any discretion to read the DFL Constitution and its proportional representation quotas to see if they violate the Minnesota or U.S. Constitution. He just enforces it as a clerk. Now, I anticipate state officials will mount the argument in defense of these facts that the statements are outrageous. But if you inquire into them, you will find they are absolutely true. And so I'm asking people in the Independence Party, or just independent voters, even those who might think they are Democrats, to look at this. Because if you just vote for the candidates endorsed by the parties on the August 12th U.S. Senate primary ballot, or if you don't vote at all, you will affirm these unconstitutional practices. You will embrace this constitutional crisis as your own. And if you don't kill it, you'll make it stronger, and you'll weaken your own freedom and liberty. Now, the problems associated with the second area of serious constitutional fissure of crisis, religious liberties, are familiar. The press has pigeonholed them as social issues, and the Independence Party ruling clique since 2010 has pronounced them as a doctrine, which they misleadingly label social tolerance. According to them and their endorsed candidates, don't even talk to them unless you accept homosexual and lesbian marriage, abortion on demand, total deregulation of all drugs, alcohol sale on Sundays, and destruction of religious liberties enshrined in our U.S. and state constitutions, as I will describe to you. First off, let me just say that our religious liberties are simply described in the First Amendment as free exercise. We're allowed to exercise our religious beliefs in every aspect of our lives as Americans. But we can't force others to attend, erect, or support any place of worship, or to maintain any religious or ecclesiastical ministry against their consent. That's the Establishment Clause, which prevents Congress from forcing this conduct on anyone. The words describing what that means are from our state constitution. If you read the controversial Hobby Lobby opinion handed down recently, you get the impression we are in the age of regulating religion. Government regulating religion doesn't fit into the First Amendment idea of not establishing a state religion or allowing free exercise. It just kind of happens because of the conflict surrounding religion. And if you read Hobby Lobby, Justice Alito's majority opinion, it supplies a good history of how we got here. And the history shows the difficulties in granting freedom of religion and religious liberty. Let's look again at what our Minnesota Constitution says. I want to cite the Minnesota Constitution to show you the extent of the Minnesota constitutional crisis, but also to show you the constitutional protections we enjoy, in which we must avail ourselves of. Minnesota has a Bill of Rights. It's Article 1 of our state constitution. And Section 16 reads as follows. And as I read from the Constitution, and you think about the intrusion into the institution of marriage carried out by the DFL in 2013, you'll sense the state's own constitutional crisis. Section 16, freedom of conscience, no preference to be given to any religious establishment or mode of worship. The right of every man to worship God. Did you know God is in our state constitution? Did you hear about that in the public schools? According to the dictates of his own conscience, shall never be infringed, nor shall any control of or interference with the rights of conscience be permitted, or any preference be given by law to any religious establishment or mode of worship. But the liberty of conscience hereby secured shall not be so construed as to excuse acts of licentiousness or justify practices inconsistent with the peace or safety of the state, unquote. And the enumeration of rights in this Constitution shall not deny or impair others retained by and inherent in the people. Now this in itself would keep protected the inherent practices and traditions of marriage. They may not be assaulted, as they are, by the DFL, because they are already enshrined in our Minnesota Constitution. It did not need to be amended to accomplish this in 2012. And the DFL practices are in violation of that constitutional and inherent right. Further, to Christians and many other religions, this new idea of homosexual and lesbian marriage is referred to in the very Constitution itself as forbidden acts of licentiousness, that is, homosexual relations. Further, this new practice does endanger children, exposing them to adoption, and is being used by Scott Dibble and his supporters to brainwash children and attack the guidance of their parents and churches to silence them. Common Core actually pushes new sexual training on all of America's children, and it is dangerous, and I'll talk about it in my education video. As I've said, we also face a federal constitutional crisis regarding religious liberty and freedom of conscience. And we have every right to rely on the protections in our state constitution in addition to our U.S. First Amendment rights of free exercise. How did this all happen? Well, first, I'll point out that the state of Minnesota just relatively recently began to license marriage at all, and legislators used that licensing power, combined with provisions of the state's Human Rights Act, protecting against discrimination and basic rights against homosexuals and lesbians, to get control of marriage and violate the state constitution and destroy marriage as we know it. Now, how did the First Amendment and the inherent right to marry between a man and a woman get so tangled up so that now we have hordes of faithless federal judges who are striking down state laws where they did succeed in shielding their inherent rights of marriage in state law or constitution? And by the way, if elected to the Senate, I would move to impeach those faithless federal judges who strike down these state laws and constitutional provisions defining marriage, because they, for political reasons, are disregarding the inherent sovereignty of the states in our Constitution, which they are required by their oath of office to follow. And I'd move to impeach the Attorney General as well, but I hear he will not be continuing on after 2014. What these faithless federal judges are doing is creating a new common law recognition of couples as constitutionally equivalent to married man and wife. It's untenable. I don't want to get too technical, but I think if you look at the history of the Supreme Court and the federal courts, you will see the problem involves common law judges having their way with the Constitution to the point of actually violating the Constitution. Look back to one of the first U.S. Supreme Court justices, Chief Justice James Kent, and Harvard's Perry Miller, an eminent intellectual historian, tells us. Kent says that when he went on the Supreme Court in 1798, there were no reports or state precedents. We seem to have no law of our own. Nobody knew what the law was, and all the time he was Chief Justice, no counsel could quote to him opinions of his predecessors. There were no American law books, and of those imported from England, there were so few copies that not all courts could consult them. It was a desperate moment indeed, says Miller, citing a Massachusetts Chief Justice, when we had to enlarge old rules, that's from England, to infuse the system with a vital equity. That's when judges don't follow the written law, but apply their old common law customs. We needed somebody the equal of Lord Mansfield, the Englishman, quote, to breathe into our common law an energy suited to the wants, the commercial interests, and the enterprise of the age, unquote. I don't find that in the Constitution. Again, to cite Al Franken, though, if you have listened to this, I'm impressed. Please don't fall asleep, not in the middle of a constitutional crisis. Because the solution to this was to import England's common law and to train lawyers to apply the common law in place of our written constitution. You might not know that England does not have a written constitution. I'm not saying they didn't have one in 1798 when we followed their laws. I'm saying they still don't have one, and I don't think they ever will. So America is unique from a legal point of view. We have one. So when the Chief Justice said, we seem to have no law of our own, he was ignoring the written U.S. Constitution. And it's also striking that the U.S. Bill of Rights was decided to not be applicable to the states like Minnesota. Only in the 20th century did the U.S. Supreme Court even begin to apply them to Minnesota and the other states through the 14th Amendment, which was passed in the 19th century. So this protection I read you from our Minnesota Constitution, which was passed in the 19th century, would apply. And as we look at these intrusions into marriage by the DFL trampling our state constitution, we're looking at our Minnesota Constitution and its protections of religious practice and freedom of conscience being challenged by United States law, and a campaign of ignoring our constitutional rights. Now, our American Constitution is this express contract, and what that is a written document that is supposed to govern our laws, and in this case, protect our religious liberties. And by the word contract, it signals some kind of an agreement. Some would say a covenant. Now, only the judges didn't think the U.S. Constitution was clear enough, so that they had to infuse it with equity. And so to give you an illustrative example, or I should say an illustrative example, because it certainly is not illustrative, the Supreme Court judges made decisions such as to allow slavery of African Americans because they supposedly weren't protected by the U.S. Constitution in its Bill of Rights. Can you even imagine this in 2014? No. According to the Supreme Court of that day, expressed in the Dred Scott decision about a man who escaped slavery and came right here to Fort Snelling when it was a territory, Minnesota was a territory and not yet a state, and he sought his constitutional right of liberty in the U.S. Supreme Court. But the court held that he had no right to appear because he was chattel, he was property, governed by the state law of Missouri, in which the good people of the Supreme Court would not interfere. Well, Abraham Lincoln took umbrage to this, and it's in the debates with Stephen Douglas, senator of the state of Illinois, which led to Abraham Lincoln becoming president of the United States, and the Civil War ensued, in which African American slaves became legally free. The point is, this same equity and common law has now been implied in violation of our state constitution and inherent rights. These inherent rights predate the positive law written in the Constitution. It's positive in the sense it's written down, not that there's anything positive about how it's being ignored, to attack our religious rights and liberties, including forced support of abortion and abortofacients, certain kinds of birth control, and now marriage. Religious rights protected by the words of our state constitution, if not the deeds of the government. And I believe this is a constitutional right, and we need to push back against this in the 2014 Senate primary, because after that, it won't come up again if I don't go there and raise it. Because these things are so complex and probably seem like new ideas in the political debate, I'm going to treat the remaining issues in a second video on constitutional rights. Now, I realize that this discussion might seem so dry and so remote and unrelated to the soundbite political ads, or even what you've discussed in school history classes, that you might just totally ignore it, but we can't. The silence of my opponent, Al Franken, and his DFL associate, Amy Klobuchar, a lawyer after all, must be broken. They must address this constitutional crisis. They must be held accountable, along with Mark Ritchie, Lori Swanson, the Attorney General, up for re-election, and Governor Mark Dayton, also up for re-election, to restore our constitutional rights under the election or elective franchise provision and the Bill of Rights, rights of conscience, and religious freedom provision. We cannot follow the common law, the judge-created law that many label judicial activism. We must have the express written protections of our Minnesota Constitution. And I must be elected August 12th, face Al Franken, and go to Washington to work in the United States Senate to pull America back from the brink of trampling and extinguishing those little liberties promised in our Constitution, which today looms so large and bright. I'm Steve Carlson. Thank you for listening, and naturally, I approve of the contents of this campaign video.
Take it count. Let the voters govern. Our democratic system makes you the sovereign. not a Republican, not a Democrat. Don't have a safe seat, not immune from defeat. I'm running for my office and I'm not standing pat. My congressional district stuck on Democrat. I want more economic development. I'm running for the House as an independent. Let's give the people back a little liberty. Let's let them all invest in their economy. Let's give them a chance to show their industry. Our hope lies not in homosexuality. Our hope lies in real marriage and voter ID. Let's break open the quota. Let's bring back Minnesota. Let's join the party of independence. Let's leave a world for our descendants. Let's bring them up so they can learn. Let's work together so they can earn. Let's help them raise a family. Let's build a just community. Make it count. Let the voters govern. In our democratic system, you know you're the sovereign. Look for change. Look for the unity party. In 212, we need American Community Party. We still have same-day registration. You just got to find your voting station. Then vote in the morning or vote in the night. Just vote to set your nation right. Vote for change.